All right, good evening. My name is Anju Fujioka. I'm a lawyer specializing in sexual assault and abuse. Today, I'm going to be introducing you to the basics of pursuing a sexual harassment claim at the Human Rights Tribunal of Ontario. So this is an option that can be pursued in addition to criminal proceedings or the criminal process if you've experienced especially sexual assault. Or it can be an alternative to pursuing a lawsuit in court for sexual harassment or assault, which we covered during a previous RRAI session. So if you have any questions today, for the most part today will be a big picture overview just to introduce you to the system and the fact that this is an option that may exist. But if you have specific questions, feel free to reach out to me at any point. My contact information is on the presentation as well. So before we get into the subject matter, there are a few things that I want to make sure we cover. So the first thing is on confidentiality. Clearly, if you have any questions today during a Q&A portion of this presentation, if you are attending live, then please keep your questions general since it will be recorded. And then this will be available online for the public, so that's why we'd like to keep it general. And everything today I'll be saying is really legal information. It's not intended to be specific legal advice. So again, if you have questions about your rights, your options, I strongly recommend that you seek the appropriate legal information from counsel. So without further ado here, let's see if I can get this to move. All right. So to start today, I want to talk about the human rights system here in Ontario and Canada. So everyone in Canada is entitled to the same fundamental human rights, including the right to equality and dignity, to live free from discrimination and harassment. So in Canada, human rights are protected both by federal, provincial, and territorial laws. So each province, for example, including Ontario, has a human rights code or an equivalent type of legislation, and there's a federal version as well. And for today's purposes, it's a long enough piece of law, but I think the key part around that is at its introduction in Section 1, where it says every person has a right to equal treatment with respect to services, goods, and facilities without discrimination because of race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, marital status, family status, or disability. And I think you can start seeing there why this is the kind of legislation that might apply to sexual harassment or sexual assault cases as well. So there's several, there are various types of sexual violence, and there's some types that can also be considered a violation of your rights under human rights laws. So the first one, let's say sexual assault. That may be a term that a lot of people know already. Usually when we talk about sexual assault, we are talking about any actual conduct or any threatened unwanted contact that violates a person's sexual integrity. So what does that mean? That means sexual touching or contact, or the threat of sexual touching or contact without your consent. And sexual assault is a crime under Canadian law. And the other term that's important here, and that's how this presentation was framed as well, is sexual harassment. So sexual harassment can include any unwanted sexual advances, verbal or physical. That being said, sexual harassment is a little bit different from sexual assault in that it's not a criminal offense in itself. It's, unless of course it meets the definition of sexual assault, because sometimes they can, sexual assault can be sexual harassment or another sexual offense. So that can be something like publishing an intimate image or criminal harassment or voyeurism. If the type of sexual harassment that you're going through also fits into one of these other already existing categories of sexual assault under Canadian criminal law, then it's a criminal offense as well. But importantly, it doesn't have to be the type of sexual violation that's also a criminal offense for it to be something that you might be able to pursue in the human rights system. So if you were sexually assaulted or sexually harassed in certain contexts, then you would have the right, or you have presumably the right to protection under human rights laws. So these contexts that we're talking about, it's with respect to your housing, vocational service, with respect to contracts, your workplace, the provision of goods, services. So it's a very wide, it captures a wide variety of contexts where human rights laws might apply. And for today's webinar, when we're talking about sexual harassment, I'm using it the way it's really understood by when we talk about the Human Rights Code as an umbrella term that encompasses any unwanted physical or verbal behavior that harms, offends, or humiliates. And it can include single incidents of sexual harassment and assault. It can also include multiple, a pattern of conduct or multiple incidents. And the last piece here, in terms of the introduction or definition to the system, is just the Human Rights Tribunal of Ontario. I've already kind of mentioned it very briefly, but that is the body or the organization that decides whether or not someone's human rights have been violated. So if you think you have a potential claim arising, from a human rights violation, that's submitted directly to the Human Rights Tribunal of Ontario. And I should note that that's a very distinct system from the courts. So, the Human Rights Tribunal is a specific organization or a body that's created under the laws, the human rights codes, the human rights laws, and that's distinct from the court system, where you would pursue a civil law lawsuit or the criminal process. Now, a few things about, actually bringing this human rights claim. So in terms of, first of all, who are you bringing this claim against, or who are you going after, maybe, to put it colloquially? They're usually brought against both the individual, the offending individual, so the person who either sexually harassed you or or who's been engaging in this kind of repeated sexual harassment, but also the organization that's responsible for governing or overseeing the behavior of that individual. So as an example, if you're experiencing sexual harassment in the workplace, then you would be typically bringing a claim against not just the person in the workplace. It could be a boss, it could be, a fellow employee who's sexually harassing you. But you would typically also bring a claim against the employer themselves for, failing to protect you or not having adequate policies to prevent this or failing to address it once it happens. So typically you'll have both, the person who is sexually harassing and that organization named. And so in terms of, where can this arise, or where can this behavior that rises to the level of human rights complaint arise? It can be, and this is all under the law itself, it can be at work or in the context of employment. It can be in a housing situation. So that you can include sexual harassment in a student residence, in apartment buildings, in condos, co-ops, or any kind of shared residence. It can also apply while using a service, and this is really broad, what a service can be. So it can include attending university or a school. So if you're experiencing sexual harassment in the university context, or that might also overlap with employment, or it can be if you go see a doctor and there's sexual harassment there, or if you're shopping at a store, that's another service. Right? So it can occur in those contexts. If you experience sexual harassment in a facility, so think at a gym, or or in a business with a commercial lease, in a contractual relationship with someone or some organization, or if you experience sexual harassment as a member of a vocational organization. So if you're a member of a trade union or something like that, and it happens within that context. There's a wide variety of situations that can be captured under under the human rights legislation. And here I'll pause to say one thing to note too is that you might see, there are things here, for example, university, where human rights might not be the only path you have. So in that case, there might be an internal disciplinary mechanism as well, right? There might be an internal complaints mechanism that you can pursue. You might be also able to pursue a civil lawsuit instead. So human rights is just because something fits in the human rights system, or just because you may have a human rights tribunal option, doesn't mean that it's the only one. Same thing if you're thinking about doctors, right? There are regulatory bodies also responsible for oversight. It might be something that rises to the level of a criminal offense. So it's always if you find yourself in those situations, it's always well worth it to speak with a lawyer or get some legal information or advice on what your options are, what all those options are, and then make smart decisions so that you're not, overlooking certain things that might be available to you. Anyway, so timing. So this is a key one when it comes to the Human Rights Tribunal, the issue of timing. And it's a tricky one. It's something that I find it can be a big barrier to actually using the system. So the reason being, in the Human Rights Tribunal has a very short time limit for you to be able to bring a claim. So say there's one incident of sexual harassment, then this 1 year time starts ticking from the date of that sexual incident of sexual harassment. If it's been a pattern of conduct or multiple incidents, then that time, the 1 year time, starts on the day of the last incident. That being said, 1 year is not a long period of time at all, right? Like in other contexts, when it comes to sexual violence or sexual assault, in the criminal sense or in the civil kind of courts where you're bringing a lawsuit, they've abolished this limitation period because they've understood that it can take a long time for survivors to come forward, that there are a lot of barriers to coming forward, and then this 1 year limitation period is, quite not all that realistic. But in the Human Rights Tribunal context, this is a very hard deadline or restriction that you have. So if you fail to bring a claim within that 1 year limitation period, there's a very good chance that you won't have an option to bring a claim before the Human Rights Tribunal. And even though the tribunal, the governing law, does allow for an exception, it's very rare that that's granted. So I would, typically we wouldn't advise anyone to really rely on that exception, and really it's best to consider it, kind of consider that 1 year time limit as a very firm one. Now, when you talk about timing, there's sometimes you might also wonder, well, when do I bring it in relation to other legal proceedings that are going on? So, with a criminal proceeding, you can bring a Human Rights Tribunal application at the same time as you go to the police or make a complaint. Typically, they'll, stay the proceeding while the criminal proceeding, or they'll put a pause on the human rights proceeding while the criminal one concludes. But you still want to make sure if, if you want to bring a human rights complaint, that it's brought within that 1 year time limit. The more complex one is maybe the civil lawsuit situation. You cannot have both a civil lawsuit and a Human Rights Tribunal application in most cases. So, again, this is one thing that you'd want to speak with a lawyer about. There are pros and cons to both. Sometimes you might have a civil lawsuit, but not a human rights option, or vice versa. Or you might have both options, and then you have to decide, should I bring the human rights application or should I bring the civil lawsuit? So that's something to consider, but you can't most of the time you cannot have both. So it's something to consider. Now, the process. I won't go into too much detail on this one. At the end of the presentation, I will have a link to some resources, especially the Human Rights Legal Support Center that really sets out the process in some detail. But overall, the process really starts with you filing an application. So you file an application with the Human Rights Tribunal of Ontario, and it'll, in the application, you will identify who you think is responsible, or the organizations. Those are the ones who will call the respondents. And then you'll provide a detailed account of the events that led up to your claim, and why and how each one of those respondents are responsible. And then you'll also have to explain, what areas of the Human Rights Code you think were infringed, what you want to have as a result of that application, and do you want to see any changes in the policies and practices of the organization responsible, and whether or not you filed any other complaints about this with other legal bodies. So you'll submit that application, and once you submit that, then you will get a letter that contains your Human Rights Tribunal file number. So the tribunal will then review your application to figure out the next steps. Sometimes they'll find that an application is incomplete, so they may send it back or ask you for more information. But if it is complete, then that application is then sent to the respondent or respondents named in the application, and any other parties that might be affected by it. And the respondents will file a response to your application. So after all of this is done, the tribunal will get on to the next step, which is asking the parties to see if they want to engage in an optional mediation. So it's not mandatory, but the Human Rights Tribunal does, recommend or at least encourage that parties consider mediation. And what this mediation really is the goal is to help the parties reach an agreement of sorts, or a settlement, or an agreement to resolve all the matters in the application. So this is really an effort to try and settle a matter before going all the way to a hearing or going through all the rest of the procedural steps. And so the Human Rights Tribunal typically uses this active listening approach where both parties get to, or all parties get to tell, the mediator, who's a neutral party, about what happened, what they want to see done. And the mediator is, like I said, a neutral party. They don't have any binding power. So you only come to any settlement as a mediation if all the parties involved agree to it. The mediator is just there to help you resolve the claim or the application if possible. This is a confidential process, and so if it succeeds, great, you have a resolution at this stage. If it doesn't, then you start going through the procedural steps of going towards a hearing. So what this really involves is, you will have to start going through a disclosure process where you are kind of exchanging relevant information. You go to a hearing where you are adjudicating, or sorry, not you are adjudicating, but you're really arguing a position. And there will be a decision made. So now that decision isn't something about a mutual agreement. That decision really is something where the adjudicator, the decision maker, decides, whether or not you did in fact experience discrimination, and what any remedy should be. So during the hearing, parties can question witnesses, you can introduce relevant documents, you can make arguments, and that is you go through that full process during the hearing. Now, there are options to, if the decision doesn't go in your favor, there are options to try and ask for reconsiderations of decisions, or have a court review the decision to see if it was reasonable, or if it was, if they came to the right conclusions at the hearing. But we won't really cover that in too much detail here. So I think the next thing I want to go through is some of the pros and cons. And I think this is, if you take something away from this, I think it will be, number one, that you should, consider all options. If you've been sexually harassed or sexually assaulted, talk to a lawyer so you're not making decisions blindly. About the 1-year limitation period, because that is key. And then some pros and cons about the Human Rights Tribunal option, or bringing claim with the Human Rights Tribunal, and its comparison to the civil law system, since oftentimes you can't have both. So the pros here, or the benefits of the Human Rights Tribunal, the first one, and again, this I think will be very relevant to a lot of folks watching this webinar, is that it's oftentimes seen as being more accessible for self-represented people. So if you don't have a lawyer, you can't afford a lawyer to go through with a civil lawsuit, or, then this is typically seen as more procedurally and financially accessible. Procedurally speaking, the rules of evidence are a lot more relaxed in human rights proceedings, or proceedings before the tribunal. It's a lot less formal, so you don't have the whole courtroom protocols that are involved in a court case. And another benefit is that adjudicators are just decision makers at the tribunal. They're considered experts, or at least subject matter experts on human rights law. So they're well informed on the human rights law, the social factors, when it comes to discrimination or even sexual violence, gender-based violence. So they may understand a lot of the context that's giving rise to your claim, your human rights claim, in a way that judges in the civil system may not appreciate as fully. With the civil system, you don't get to pick your judge who's hearing it. And some of them have excellent backgrounds in human rights law. Not all of them do, or social justice concerns. So with the Human Rights Tribunal, you know that you have adjudicators who have a good foundation when it comes to this subject matter. There's some financial benefits as well when it comes to the Human Rights Tribunal. The Human Rights Tribunal will not award legal costs for unsuccessful claims. So in the civil context, say if you go through a lawsuit process, then in Ontario, for example, we have a loser pays system where if you lose a civil case, then the loser is expected to cover part of the winner's legal expenses. You don't have that in the human rights system. And so that can encourage people, or that can eliminate or reduce that deterrence, for complainants who feel like, what if I lose, right? Like, what if I lose? Am I going to have a huge cost award against me? That's not a risk you're taking in the human rights context. We'll get to this later, but there's a flip side as well, right? Because if you are successful, you also don't get to get costs for your legal expenses. So it is a little bit of a double-edged sword here. The other thing, and this is another thing that's also brought up often as a real benefit of the human rights system, is that the tribunal can order remedies that are not really available to them in the court, in the lawsuit or the civil common law side of things. So what that means is the tribunal can order systemic remedies, so instead of just saying you owe someone compensation, they can do more and order, for example, an organization to do more in terms of creating better policies or procedures to prevent, further discrimination and harm from happening. These are things that people who bring human rights complaints oftentimes want, is they want to see the systems improve. So this is a big draw for them. But as you can see here on the slide as well, there are cons as well. So to address the last point I brought up, even though the tribunal can order these remedies, these systemic institutional remedies that seem wonderful, the tribunal doesn't have a way to enforce them. So sometimes, and this is the case in civil court too, but sometimes respondents will just ignore what they were ordered to do, especially when it comes to the systemic remedies, or institutions might just, kind of do rubber stamped or do the bare minimum in terms of policies or things that they were ordered to do. And it's really on you as the complainant, the person bringing this claim, to enforce it. So what that really means is that you would have to go to the Superior Court of Justice, have the court enforce the order, and this usually would require you to hire a lawyer. And, there's a lot of work that goes into it, even if you are able to afford a lawyer to enforce these remedies. So it's not just because something's been ordered doesn't mean it's going to happen. Another thing, I've mentioned this before, but the 1-year limitation period, its time limit's incredibly restrictive. And especially, when it comes to sexual harassment, sexual assault survivors, this can be oftentimes the reason why they are not able to pursue any meaningful justice. Another thing I'll say is the complexity and power imbalance here. So for self-represented people, even though the human rights process or the human rights tribunal process is a lot simpler than trying to bring a court case, a lawsuit, it is still not, completely simple. And oftentimes the respondents, or the person and the institutions that you are complaining about, they will have legal counsel, and good legal counsel at that. So if you are a self-represented person going up against them, you are clearly at a disadvantage. And, even though they try to make the system more accessible, it is still not something that's easy. It's time consuming. So it's definitely not a walk in the park. And the last thing I'll say here is on delays. when I went through the process, I might have made it sound like it's a very quick thing. You file an application, you go step by step, it's done. Not really the case. There is truly a multi-year backlog of cases. So the delay, and sometimes a human rights complaint can take a lot longer than a civil case to resolve as well. So it's well worth, again, I think I come back to this every time, but it's well worth at least getting some legal opinions on what to do or what might be the best course of action for you. And that brings me to resources, because we can all use some help if we find ourselves in trouble. This is by no means an extensive kind of, this isn't the end of, exhaustive list of assistance available, but the first one that I want to highlight is the Human Rights Legal Support Center. The website's there, they have a phone number. They can help, if you qualify, they can help provide assistance with resolving disputes under the Human Rights Code. They can help you file an application. They can help you they can help you go through that mediation, and I think they also provide help enforcing orders of the Human Rights Tribunal. So they are specifically there to help with human rights claims in Ontario. Their website as well is very robust. They keep it updated, and there's a lot of information there. So if you are considering going it alone and filing an application on your own, definitely access the information that they provide on their website. And if you need assistance with your claims, I think they should definitely be one of the first places you contact. Another resource that might be available to some of you who've experienced sexual harassment, especially if you've experienced sexual assault, is the Independent Legal Advice for Survivors of Sexual Assault. This is a free program. So if you live in Ontario above 16 years old and you've experienced sexual assault, and then you're eligible for up to 4 years of 4 hours, not years, of independent legal advice from a lawyer specializing in this area. So I've done a more fulsome little webinar on this as well, but the application is simple. You email it to them. It's a 2-page application that some basic questions that you fill in, and you can speak with lawyers who can help guide you through this as well. So those are 2 pieces, 2 resources that might be quite helpful. And yeah, and then last thing here is just my contact information. If you do need to connect, feel free to reach out, or and if I'm able to help, it would be my pleasure to do so. So that takes me to the end of my presentation. Yeah.
Thank you so much, Anju, for this very direct, straight to the point presentation, very informative. If I may ask some questions, could you please clarify the difference between sexual harassment and sexual assault?
Absolutely. So sexual assault typically involves, and that's what we're talking as the crime. So sexual assault, any touching or the threat of touching that and that is of a sexual nature, and that's without your consent. Sexual harassment is a little bit broader, so it can also involve, words or conduct of a sexual nature that are insulting or offensive, or that so it can also include sexual assault, but it doesn't. It's a bit broader than that.
So it might be a joke.
Exactly. It could be a joke, an unwanted comment, or, someone who's repeatedly looking at you in a leery way. So where you're not afraid that they're touching you, or they're not touching you, but it's still sexualized, and it's, what we would call inappropriate. It feels wrong, right? It's offensive. A lot of the times that can fall into that sexual harassment.
And it's a case by case. It will be evaluated on a case-by-case basis, taking into consideration the whole situation.
Exactly. So if you're thinking any unwanted sexual advances, verbal or physical, a lot of the times that will fall squarely. But yes, there isn't a list of, actions that are specifically sexual harassment, but I think we generally tend to have an idea of what is inappropriate or what might be sexual misconduct. So if you feel that it was, unwelcome sexualized comments or unwelcome sexualized touching, or if it was inappropriate. Because I think that's really the language we tend to use is misconduct or inappropriate, because we don't necessarily always talk about it was sexual harassment. It might be worth a time to just, talk to someone and say, would this fall under that umbrella?
I see. Okay, so on the other side, can we file human rights file while, for example, a criminal case is going on at the same time?
Yes. So, and that's actually quite important. So, there are pros and cons to starting proceedings. So in the human rights case, human rights tribunal situation, you have that 1 year time limit. So most criminal cases will not conclude within that 1 year timeline. So you want to make sure that your application is filed with the human rights tribunal before the 1 year timeline is over. They will typically put it on hold until the criminal matters, finish, or they might stay. That's what we mean by stay, is put it on hold, but you don't want to miss the deadline. That being said, again, this is a situation where you might want to talk to a lawyer, because there are a lot of considerations that go into this. If you file a human rights complaint and, and there's a criminal process ongoing, maybe the accused person will say, look, there was a motive for you to make this up because you wanted some kind of remedy or compensation through the human rights regime. So that's why you complain to the police, and it's not because it happened. Or they might try to use that to challenge your credibility, or challenge your motivations for bringing this for, making that criminal complaint in the first place. So that's very much a case-by-case situation. Or maybe, maybe it's better to bring a civil lawsuit at the end of it instead of going forward with a human rights claim, because the civil lawsuit a lot of times doesn't have that same 1 year time limit. So there are a lot of things that come into play where I wouldn't be able to give blanket advice on, you do this first and do
For
this.
instance. Yeah. So on the other side, when the tribunal investigator, if I may, or evaluate any case, they will evaluate it based on balance of probability or the beyond reasonable doubt principle.
Great question. I should have actually covered that. So it will be on a balance of probabilities. They're not evaluating it on a beyond a reasonable doubt standard. So for those listening, balance of probabilities is more likely than not, as opposed to beyond a reasonable doubt, which is you must be essentially almost certain that it happened. So you don't have any reasonable doubts that it didn't happen.
I see. And on last but not least, I'm going to ask our audience on different social media platforms. If you have any question, please feel free to type it into the chat. So far, I've asked the questions I do have. In case of none, I will take this opportunity to thank you again, Anju, for all of your support to RRAI, all of those important information you provided, you're willing to help and support, is what makes this country great, because people like you out
Thank
there.
you. And thank you
Thank
for
you
having
so
me time
much.
and time again.
By all means, it's an honor to have you.
Thank you, Adam.
And for everyone, to conclude our session, please stay safe, stay well, and we are looking forward to see you again at another session at Rights and Responsibilities Awareness Initiative. Thank you so much.